Probably 3 minutes past, so we're going to start. Take your seats, and I'm sure there's probably people still trying to get coffee. They can join us in a sec. So, pleased to introduce Silva, who's one of the most respected technology lawyers in the UK and on the BCS Law Committee and previously chair of the BCS Law Committee. So why have we invited a lawyer to talk at Sigget? Well, there's a lot of digital policy coming down the chain, the legislative chain in the UK and the EU. And obviously being digital, people are interested in how we test digital products. You can think back to the presentation we had just now from James, using chatbot AI in a medical context. There are risks. So regulators are looking at how we manage those risks. I'll talk more about this at the end of the day when we're talking a little bit about software testing standards and trying to join the bits together. But for now, over to Sam.
Thanks, Adam. So I am introduced as the most respected technology lawyer. I'm not sure about the respected, but I am a technology lawyer. So I'm a partner at CMS, or Cameron McKenna Navarro Olswang LLP, probably the law firm with the longest name. So a bit about me is, as Adam said, I'm chair of the BCS Law Institute, still chair unless I don't know, and I'm also a BSc trustee and a council member. So what I'm going to talk about is the AI regulation, how it's been applied, conformity with conformity assessments, talk about penalties and enforcements, some summary and practical steps. Now, why I added that in, the AI Liability Directive, do you know why I added that in the last minute? Because that only came out about 3 weeks ago. So my presentation was fine, and I go, oh God, I've got to add something else. So there are a few slides on there, and I think obviously, given it applies to AI, it is important to talk about it. So everybody talks about this AI Act as if it's in force. Stepping back, it's an EU piece of legislation. So you're probably wondering, well, Brexit, why do we care? Well, unfortunately, we have to care because it does have extraterritorial application, and I will talk about how it will apply to UK businesses if it's applying AI into the EU. So just because it's EU, we can't unfortunately ignore it. It's interesting to note the UK approach to AI is basically they're saying we're not going to regulate, it will be up to the regulators. Whether they sort of follow with that approach remains to be seen, but I think the challenge will be if the UK don't regulate AI and the EU and maybe even US and other jurisdictions do regulate, we'll get into an area where there is a conflict of laws and it's not a level playing field. So I think there is an issue there in terms of consistency with laws and whether some laws are more stringent and whether some jurisdictions don't have laws. The purpose of this slide is to just demonstrate that it's not a done deal, yeah? So as you can see, there has been a lot going around in the background, and we're still not at the final stage. Now, if we compare the AI regulations, the GDPR sort of regulation, I think that was probably thought about in 2002, 2003, and it finally got approved in 2006. Then there was a transition period of 2 years when it came into effect in 2018. So, we are talking quite a long time. So the commentators are saying that this will come into effect or get sort of approved through the trilogue process, commission and committees sort of early next year, later next year. I think only time will tell, but I think there is a lot of work still to be done. And there's a number of drafts floating around in terms of compromise drafts and so forth. So, I think there's a bit of a misnomer. People think, Act, it's already enforced. No, it's not enforced. It's in draft form. It hasn't been approved, but there is quite a bit of more work to go. So I'll obviously only sort of comment on the basis of what I've seen in terms of the draft law, because it's not law in itself. So has anybody looked at this draft regulation? Yeah, Adam would. I knew he would. So it's not probably my view, it's not probably the clearest of legislation, and the way it's structured, you could argue it's sort of helpful and not helpful. So it's done in probably about, number of sections, and we'll talk about those in the next slide. So each of those sections consider certain things. So I think when you're looking at the AI regulation, how do we need to sort of consider that? So we need to say, what does it apply to? What activities are relevant? is it a prohibited sort of AI activity or action? Is it a sort of a high risk AI system? And how does this sort of regulation apply in relation to specific operators? So there's a number of stakeholders in the AI chain, developers, users, and we'll talk about that, the supply chain, and where as testers, where you would sort of fall into that. So where does the AI regulation apply to? So as you can sort of see, it's very broad, and it probably covers, if you look at the actual words, it probably covers less cutting edge technology than people may actually think what AI is. So it's meant to be broad and generic. It is actually tries to be future proof. So there's a process there where basically the commission can update the definition or add specific things so it makes the definition wider. So it's not sort of set in stone. I think because it's such a broad and general definition, it also can sort of capture things that you may not think is AI in the true sense of the word. So for example, widely used sort of search algorithms, that will be caught by the definition. We think, well, is that AI in the sense? So if you look at sort of the definition, it's basically software, yeah, fine, and then it's developed with one or more of these specific techniques in mind. And I said, as I said, it is future-proof in the sense they can add to it. So just from your perspective, from a technical perspective, what do you think of the definition?
Generic, isn't it? It's a bit generic.
Yeah.
Yeah, very like vague in nature, it seems.
Do you think potential, my view is it potentially probably captures things which are not in the true sense of the word AI, which I think is a problem because obviously if it's high risk, then it's caught by the regulation. So there is quite a bit of debate about the definition. So something to bear in mind because obviously the definition is key to this whole thing. So what activities are relevant? So in terms of a provider established inside or outside the EU, and when they're doing that, i.e. placing into the market, they are putting into service in the market, they're actually covered. Use of an AI system located within the EU, provider or use of the AI, which is located outside the EU. Operators, we'll talk about that. So in terms of the territory, so non-EU based organizations, for example, UK, who provide AI systems into the EU will be caught by this legislation. So it does have extraterritorial effect. So you don't need to be a EU based organization. Now, where an EU organization sort of contract the non-EU organization, so let's say a company in the EU in France contracts with a company in UK, the non-UK operator, i.e. the person, so the French is the supplier of the EU system, the AI system, UK customer is the customer of the AI system. If they're actually using the AI system and they sort of process the data and it's sort of transferred from the EU, and then they provide the EU company with the output of the data, that operator, or well, I guess the operator or user in the UK would be caught by the EU Act, even though they're not placing they're not the actual provider, yeah, they're just the user, but by that processing of data in the EU, they are caught with the Act. So you can see that, it does have relevance for UK companies. So territory, so exceptions, there are exceptions. So obviously military applications are not covered, law enforcement's not covered, and then intermediary service providers, which are covered by the e-commerce directive, are also not covered. But it links to high-risk AI systems. We'll talk about that in the next slides. And then it also talks about sort of how it interplays with existing EU legislation, such as the medical devices regulation. So what is a prohibited AI practice? So this is basically, the big sort of no's, you can't do this. So use of subliminal techniques, targeting specific vulnerable people with a particular disabilities or age, social scoring factors such as China uses and other countries use it, real-time sort of biometric surveillance, unless it's sort of targeted specifically search for a crime or prevention of a particular crime or detection of a particular crime. So there are exceptions there. And then the regulation sort of differentiates between three types of risk. So unacceptable risk, high risk, and non-high risk or low risk. So effectively what they've said is that in terms of the high risk, what they're saying is that they believe that there's certain AI solutions that will affect fundamental rights and freedoms of people, and that's why they're prohibited, and that's why it's illegal under EU law. So I think when you're looking at the regulation, there's a number of questions you need to ask. So first question is my AI system high risk? If it's high risk, does it fall within Annex 3 of the high-risk AI systems? And the parallel question is it a product safety component governed by EU harmonized legislation, i.e. legislation which is already in place, such as medical device stuff? So basically, I think the impact of this is that, I guess, organizations involved in, let's say, medical, education, energy, HR, public, financial insurance, justice, immigration sector. So quite a few sectors are potentially affected. So they need to think about how this will affect them in terms of their organization. Now, if it's classified as high risk, which is set out in Annex 3, so these are the specified high risk AI systems. I'm not going to go through this in detail, but basically biometric systems, management critical infrastructure, education, employment, law enforcement, migration, administration of justice. So those are ones which are the EU Commission says that they're deemed to be high risk, and obviously different consequences flow from that. In terms of that other question that we talked about here, is it a product safety component governed by EU harmonized legislation? Effectively, that's used as a safety component in products. It could be the products themselves. So what we're talking about here is machinery, toys, medical devices, which are already covered by EU legislation for product safety. And also there's other things such as boats, rail, motor vehicles, aircraft. So those things are already covered, and they will be classified in terms of the AI system as potentially covered and potentially high risk as well. So when you're looking at sort of high risk, it basically looks at from a perspective of how does it affect the health and safety of people and the fundamental rights of people? So those are the two criteria it looks at when it's classified as high risk. It doesn't sort of focus on basically the sector or the intended use of the AI system. So it's not saying because you're in your financial services or because you're in medical, it's high risk. It's more about, can the actual solution actually affect as I said, the health and safety of people or the fundamental rights of people. So as I said, these are the sectors which we think will be possibly affected by the high risk system. Anyone think there will be any other sectors?
Why immigration? I thought that was an exclusion.
It's only excluded to a certain extent.
Okay.
Yeah. Like all things, there are caveats to the exceptions. Yeah.
Would military or some government organisations be other sort of areas to consider in the future?
So military is excluded.
Okay.
So anything AI, for example, drones, AI technology using drones to, kill, things or targets, that's excluded.
Okay.
Yeah.
There's no telecoms on there. Does that come under any of them? Was that?
I mean, yeah, potentially, I guess. I mean, I guess it depends on how the AI is used in the telecom sector.
Yeah, so who gets a stronger signal than someone else? For example, who gets 5G versus 4G today, based on your anything,
Yeah,
credit
Yeah.
score, how much business you give that provider.
yeah.
I just wondered why it wasn't on the bullets there when you were asking if there was any missing.
I don't know.
Okay.
Yeah,
fine.
yeah.
Well, I'll go and Yahoo it on Google later.
I think anything that governs people's access to services based on who they are.
This
Could be
social
effective.
scoring is high risk.
Yeah.
Yeah,
I was gonna mention that, like surveillance
Mhm.
too, because it could be used for social scoring.
Yeah.
Similar to what it's done.
Yeah. yeah,
Transportation's another one that could
Yeah.
potentially
yeah,
be impacted.
yeah.
Autonomous vehicles, things like that. Yeah. Thank you.
Yeah. So the requirements for high-risk systems, so if it falls into a high-risk system, if you've got an AI thing, which is classified high risk, what do you need to make sure? Well, you need to make sure there's a sort of risk management, it's all covered. You need to make sure there's high quality and data governance, technical documentation, record keeping, automatic logging, transparency by design, human oversight, and accuracy, robustness, security. So those are the requirements that you need in terms of high-risk AI systems. So from a technical perspective, do you think that's practical?
Not the words about data.
Yeah.
It should be representative, complete, and error-free.
I mean, that's an ideal, isn't it? That's a panacea, isn't it?
It's an impossible
Yeah. So you're doomed for failure from the start.
from the start.
On the last column there,
Yeah.
sufficiently accurate. And that's subjective, so
Yeah.
you could lower your. It's sufficiently accurate for us.
Yeah.
Yeah.
So yeah.
Yeah.
It's,
Mediocre understanding is sufficient for some people.
Yeah. Yeah. I mean, there's been a lot of debate about how practical these requirements are and how they can actually be applied. Yeah. So, yeah.
How does transparency, for example, transparency by design, how does that tie into having to reveal things that would be patent protected,
Yeah.
for example? Because you can't give away your trade secrets just to please.
I mean, there's
somebody.
an inherent conflict, isn't there, in terms of IP?
Yeah, because
Yeah.
patent protection
Yeah.
guarantees confidentiality.
Yeah.
Of,
Although patent protection is probably patent stuff is already published, so it's probably more trade secrets
Well, yeah.
and I guess copyright and that isn't published. So yeah,
how transparent can you really be without
yeah,
giving away the sauce? You know?
yeah. So do you view this as sort of bureaucrats coming up with something which has no practical relevance or limited practical?
It's bureaucrats coming up with something that they don't understand.
yeah. I think quite often the companies who do the AI may even be ahead of these guidelines potentially.
Yeah,
I think it also depends on who you go setting up as your oversight. Because the thing is, I mean, you'd have technical experts, you'd have people that were versed in risk management, etc., to go through, and it just depends on the quality of who you've got sitting there and what their knowledge base is of how that's implemented and how it's then taken from this and put forward.
yeah.
I wish it was this easy.
Well, there's still time to lobby. So, in terms of observations of these high-risk systems, so what the drafts people have said that they're consistent with sort of existing principles in terms of OECD principles on AI. They haven't gone as far as sort of specifying what the technical solutions are in order to achieve compliance. So it's very high level, as you can probably see. They are saying it allows sort of providers discretion and flexibility. Whether that is the case is, debatable. And obviously it's likely to result in sort of multi-stakeholder activity across various industries to actually get this, working. So in terms of the ecosystem, there's various, parties to the ecosystem. Depending on which party you are, you have different requirements. So as a provider, basically this is, a developer, I guess, of an AI system. Those are the key obligations. So again, be interested from your perspective, what you feel are relevant or appropriate those are.
My favourite bit
Yeah.
is affixing the CE marking to the cling film packaging that we all distribute our systems in. Really good legal language.
Yeah, that's really like, quite outdated, isn't it? Yeah.
One of the most relevant bits to us is the second bullet, maintain the quality management system. That's throughout the Act, it's talking about technical quality management systems and conformity assessment, which is the independent assessment and testing that happens here. It happens from time to time.
Didn't get a CE stamp, that one.
So the next one is authorized representative. Again, I think that's relevant for you guys, because you could fall in, as testers, you could fall into that category. I mean, the second bullet point in key obligation seems quite onerous, I would have thought. Yeah. Then the next one is the importer. Again, you could potentially fall into this category, you know, depending on what you do as a tester or a developer. Distributor. You'll get a copy of these slides, so you don't need to take notes, but yeah.
How would this work in the terms of upgrading an existing entity? So for example, I brought in the AI, I did all the paperwork, I've got it going, and then every time a change comes up, do I have to then submit, because given how software changes so quickly,
Yeah.
so often, if I have to wait, what I'm gonna assume is weeks to get clearance, release times are just gonna plummet
Yeah.
for AI. Like, how do you keep up with that and stay in regulation without, it's a giant juggling act.
We don't know yet. There's been discussions about whether retraining the model might actually require you to go back through the whole regulatory approval process.
We know if like applying overlays and models would as well, or not.
Probably in a high-risk situation, yes, but equally we might see regulation move to a more continuous and digital approach. So when you look at transparency and you talk about IP, having real-time logging being constantly reviewed by regulators might be a way to get around, to make it all very agile and fast,
Okay.
but we'll see.
And then finally, the user. So it's interesting because, it's trying to regulate the people actually using, which is quite an unusual concept, if you look at the sort of analogize this to software, as a normal licensee, you don't really have any regulatory obligation. You obviously have your contractual obligation to the licensor in terms of using the software, in terms of the scope of the license, but you don't have any regulatory obligation. So, hello.
Who's the user? Let's say Google uses AI. I'm a third party.
Yeah.
Are they the user, or am I when I do a search?
Both of you potentially.
So even though I'm using something I may not realise has got any AI in it at all.
Yeah.
Okay, interesting.
That's what I was gonna say. Most of the people who are users of this sort of software are users because they can't build it. So how are they supposed to regulate something that they don't?
Yeah.
It makes no sense.
And you may be a user, a user, provider, and an importer. In fact, most
Right.
organizations will be using someone else's components in their AI system.
Right, in maybe Google's case or a tech company, but if it's a company that has absolutely nothing to do with software, have no technical knowledge, how can they really know for a fact that they're regulating it properly or not?
Yeah.
I mean, I haven't done the exercise, but it'd be interesting to map out whether, when you fall across a number of categories, whether there's an inconsistency between what you do, because as a provider, you may have to do a certain thing, but as a user, you may not have to do that, or it might be something different. So if you do that, can you still comply with the provider obligations?
Yeah, I was just thinking, if you take someone else's AI, something like a product on the market, and you adapt it, you then become the producer of it as well. That makes sense.
Potentially, yeah.
Tech departments at every company, better for us, I guess.
Yeah.
Yeah.
Work.
In terms of conformity assessments, so I don't know what you think, Adam, but I think there's a myriad of this is pretty poorly drafted. There's pretty complex stuff really in the legislation to actually, it's like wading through treacle really. So effectively what they're saying is they can be carried out on a sort of like a standalone basis or in terms of a wider sort of conformity assessment where it's governed by existing EU legislation. So they need to either sort of comply with either a conformity assessment, which is sort of based on internal controls, which is set out in Annex 4, or they may have to do it in terms of a quality management system and technical documentation. They're also saying that for certain high-risk sort of AI systems, which are governed by sort of existing EU legislation, operators can rely on a presumption of conformity. So what that means is if there's a high-risk AI system which is already sort of conformity with harmonized standards, i.e. sort of medical devices, then there is a presumption of conformity unless the EU sort of says that they're deemed to be insufficient. So there is a bit of assistance there relying on existing conformity assessments for those things which are already regulated, such as medical devices. So there's a couple of concepts there. There's exceptions to the conformity assessment. So the assessments is the public security of the protection of life and health of persons, environmental protection, protection of key industries and infrastructure assessment. So in those particular areas, you don't need to go through a conformity assessment. Now, there's two concepts. There's notifying authorities and notifying bodies. So notifying authorities is the national sort of, I guess, authority or the regulator, which is sort of sets up for carrying out the conformity assessments and sort of notifying the conformity assessment bodies of their monitoring. And the notified bodies are basically the bodies that perform the third-party conformity assessments. I don't know, Adam, if you've got any insight in terms of who's going to be the...
Yeah, the first organisation that's decided to be a notified body is actually the British Standards Institution, which was a little bit surprising because they're not in the EU, but actually they do conformity assessments and things like medical devices all over the world, in the US, European countries and things like that. So BSI and its global kind of entity will hopefully be the first notified body for AI.
Any thoughts on the notifying authorities?
No idea.
It'd be interesting, for example, if the ICO decides to do it, who knows?
In the EU, it's clearer. You know, like Spain's just set up an AI regulatory body, but in the UK, I don't know if they'll have the authority to set up a notifying authority.
Yeah. So now to the fun bit, penalties enforcement. Probably see quite eye-watering. Jesus. Yeah, so sort of in the sort of same realms of, well, even more than GDPR, right? Yeah. But it doesn't allow individuals to make complaints, so you won't be getting data, artificial intelligence access right requests or, exactly, yeah. So in terms of, I guess, practical steps, I think compliance will be key, but then the question is, how do you comply when some of these things are so high level and so impractical in some certain fines could be significant. So basically the sort of key themes about is the governance process, the quality of the training data in terms of training the algorithm, degree of human oversight, the actual accuracy, robustness and security, and the transparency, explainability, and the ability challenge. So those are the key themes which is that regulation is trying to capture. Clearly, a gap analysis needs to be done in terms of businesses, what they're doing and, how that complies with the actual regulation, and then, the impact assessment in terms of assessing what the impact of this is on the business and so forth. So that's it for AI regulation. Before I go into the Liability Directive. Any questions on the draft legislation?
Are they putting through legislation that you have to declare from a test perspective that you're using AI to test throughout your software systems and then putting that through? Is there any sort of legislation coming through on that sort of side?
Not specific, but it'll probably be captured, I guess, depending on where you fit into that ecosystem in terms of transparency.
Yeah.
Yeah. So yeah, there's nothing specific, but I suspect it'll be captured. So I suspect it'll be on your example. You mean either provide authorized rep. So
technical documentation, demonstrating compliance and regulation, quality management, yeah. Logs automatically generated,
yeah,
etc. Yeah.
And the regulators will want to examine your test results in intricate detail, so that would come up.
Yeah, and the authorized rep. So yeah.
You fall into a couple of categories.
Yeah.
Yeah, is there any kind of concern here for open source software? Would there be any exemptions there or any reduction in any of the compliance necessities?
There isn't anything specific as far as I'm sort of seeing. I mean, at least
there is now. They changed it in the last compromise, like a couple of weeks ago.
Yeah.
So now they talk about open source, and they confirm open source is regulated as a provider of AI. There is an exemption to make it relatively easy for an open source developer to add a disclaimer saying you're only allowed to use this AI system to do this, this, and this. You're not authorized to use it for anything else. And that gets them out of a lot of the obligations.
What about liability?
Oh, I don't know, actually. I haven't read this.
Right.
The next bit yet.
Who's responsible for?
Presumably they could be fined up to 20 million
Yeah.
if they fail to
That's not
disclaimer in the
people to
repos.
Is this, so is this applied system based or is it applied use based? Because, so let's say, for example, you have software for surveillance of streets to determine possible routes for a car that's escaping, and you can sell that into law enforcement, so that exempts you. But then you can also sell that same system to a marketing company that wants to know what are the most often visited routes by people from certain areas to know what they should offer in terms of ads for specific sectors of the city. It's the same system, but because you're selling it into law enforcement, would you be exempt on both sides, or would you have to report the marketing side of it and not the law
You
enforcement
would
side?
have to report the marketing side.
So it is used.
It's not the system itself, it's how it's actually used, the application.
So we can't kind of.
No. Yeah, this can always be used for this, So in terms of liability directive, so it basically aims to create sort of certainty around liability for damage caused by AI products and services. Whilst, it's obviously won't apply in the UK because it's post-Brexit, it will, again, apply to those organisations supplying AI solutions in the EU. So it does have a relevance. And basically, it will provide recourse for users of AI systems to seek compensation for the tech providers for harm suffered through AI systems. So in terms of the two key things, there's the presumption of causality, and then there's the access to the information. So the first feature is basically it aims at sort of resolving the difficulties for claimants who suffered harm in establishing the damage caused. So, for example, the black box sort of syndrome. So, where claimants can prove that the AI system doesn't actually comply with the AI Act and other regulatory requirements, the defendant doesn't have to disclose sort of evidence required because it may have destroyed that evidence. There'll be a presumption that the actual defendant, i.e. the tech provider, has breached the relevant duty. So there is a presumption effectively that there is that cause between the harm suffered and the actual system that actually caused that harm. The second sort of feature is basically the victims or the persons who suffered the harm will have a right of requesting the information from the tech providers, so the tech providers can't sort of hide behind sort of, not able to provide that. So it does actually have a sufficient impact for tech providers in terms of liability, and it does make it easier actually to for people who've suffered harm to actually make claims. It doesn't change the onus, so it's still the onus is for the person to prove the harm, but effectively means that it's much easier to prove the harm, because that causal link doesn't have to be established. And that's obviously at a draft stage as well, and that came out about 2 or 3 weeks ago. So that obviously interplays with the AI Act as well, so yeah. So lots to think about. Any questions?
How do companies stand with, for example, the EU directive that's emerging every day, every week, and then, for example, in the US, the White House Bill of Rights that's just recently come out? You've got one AI system used globally, and they conflict slightly. How are companies going to handle that?
Yeah, I mean, a good question. I mean, it's a conflict of laws thing, isn't it? It's basically, depending on where the AI system's used and how it applies, you will have to comply with multiple
versions,
requirements and legislation.
multiple models, regional
models
models to adhere to different, and then you're kind of defeating the purpose of having AI to begin with.
Yeah, there is dialogue going on between Biden's administration and the EU team working on this, and the UK. So there's quite a lot of dialogue going on. So hopefully we'll end up with some consistency.
Copy and paste by a month. And would you say it's a fair statement that although these guidelines are there and there is a balance between innovation and fostering AI, actually this can support the testing community in that our fellow developers, business analysts, project teams now have to actually explain their models. The data scientists can't just create this wizardry. They do have to create some sort of transparency to support explainability. So potentially this can actually help the software testing community.
Yeah, I mean, I guess it's if it becomes law, it is something. Look, we need to do this. So you're not sort of you're not arguing for that from the business. The commercial people go, oh, we don't really care. Just do it. Well, we've got law. We need to comply with it.
Yeah.
We actually going to get documentation for once? Is that what you're saying?
It's exactly it.
Written documents for real?
Exactly.
It's like Christmas.
Well, I think as soon as the data science team sees the detail, they're not going to want to do any of this technical quality management work anymore.
No, but on a serious note, you have to really consider what you put into your documents. Because going back to the example of the diagnosis you were talking about earlier, if you use a term like that, you now expose yourself to being liable for a misdiagnosis if somebody acted upon what you call the diagnosis in your software to kind of look fancy. So you have to be really careful the way you address things to not expose yourself to fault.
And obviously with interplay with the Liability Directive, because that documentation is accessed by the person who suffers.
Exactly.
So yes,
because
could
say
be
like this told me I had
somewhere.
whatever, and I went and took meds and it wasn't that, and now I'm paralyzed from the waist down.
Hello.
Hi. Do we know if there's any kind of timelines on the amount of time someone could complain about something? So if a user was saying, an end user was saying, oh, I was unfairly priced for a bank loan, I think the AI was rating me differently because I'm disabled, for example. Is this going to happen? Like, can they raise something 18 months down the line, and then someone has to go and look for the model from 18 months to go and have a look, and then like, is there any kind of...
I'm not aware of any timelines, but if there isn't any timelines, then the specific law would apply. So, under English law, it'll be, 6 years.
Yeah, so in theory, you have to keep auditing every single model you have 6 years. Wow.
Potentially, yeah.
With what you were saying about the liability, it sounded like the company has to prove that they weren't at fault.
Yeah.
So you could get a lot of false claims of people going, well, yeah, this happened. And it's like trying to prove that they weren't at fault when there wasn't a case in the first place, because the user is basically going, oh, I might be able to get some money here.
No, I think, no, it doesn't go that far. What it basically says is that usually to prove fault, you have to prove there's a link between the harm you suffered and, the actual system. What this effectively says is that link is already established. So they still have to prove, for example, that they have suffered harm. Yeah. They don't have to prove that the harm has been suffered because of the system, because that that link's been done. So it doesn't change the onus of proof. So it's still up to the person to prove that they actually have suffered harm, but they don't have to prove that effectively that the system has caused them that harm.
So
So it makes it a bit easier.
innocent till proven guilty is kind of how it's gonna work. I don't have to prove I'm innocent, they have to prove I'm guilty.
No, I don't think it goes that far. It just makes it easier for them to claim that that the tech provider is, basically guilty. Yeah.
So the tech company has to say, we're not guilty because, so they have to prove their innocence.
No, they have, no, sorry. They don't have to prove they're innocent. What they will have to prove, the victim will still have to prove that they actually suffered the harm.
But they may have suffered harm, but it may not have been due to that, and they're just saying it was. So
So then the tech provider will have to sort of disconnect that link. So it's not the system that caused the harm.
Yes.
So it's guilty
False
until proven
claims.
innocent.
It seems like a money pit for a company to have, because if somebody comes in and says like, I'm sure it was this, and then the tech company has to defend themselves, it could lead to somebody just constantly having to defend themselves against a lot of cases.
Yeah.
It's like the ombudsman kind of approach and stuff, isn't it? Where it goes up to an ombudsman and then you have to do like a really expensive investigation into something.
What if their model was transparent and explainable and not biased? Then that would support the tech company.
Yeah, definitely. I definitely agree that a lot of these models at the moment are very much black box and almost unexplainable, aren't they?
Yes.
So it does improve
This
that.
will help,
Definitely.
definitely.
Only if providing explainability doesn't break sufficient accuracy, though.
Yes.
Yeah.
Is another problem. So we'll be talking more a little bit about this at the end of the day, particularly in terms of harmonised standards and presumption of conformity and what that actually means. But unless there's any more questions, I think I'd like to thank Sam for a great talk.